Now, returning to the issue of the European arrest warrant, well, it's important that within your profession and your professional practice, you have a fundamentally clear grasp of the concepts and the workings of the Interpol structures, which represent a kind of network for tracing and searching, and then an instrument for the arrest of those who are subject to precisely a warrant. In previous lessons of ASC1, we already described some aspects of Interpol. Now, in general terms, I'd like to briefly, well, let me remind you of Interpol's organizational structure, how it works, and especially what the different types of international notices are. So basically, the question is, what is Interpol and how does it work? So the Interpol organization is an international organization, obviously. In fact, it's the International Criminal Police Organization. That's what the acronym means. And as you know, it's the largest international police cooperation organization with 195 member states that have, in fact, acceded to the treaty. So the main purpose of Interpol is, in fact, to facilitate collaboration between law enforcement agencies at a global level in order to, well, combat international crime. Therefore, Interpol's primary purpose is to provide operational, technical, and analytical support. It has various headquarters. As far as Italy is concerned, and therefore also the dealings that lawyers practically have with Interpol when they file petitions, questions, requests, access requests, and so on. Well, our Interpol organization, that is the organization, the Interpol organization that concerns us, is the one based in Lyon, France. And it then relies on a network of national central bureaus, the NCBs, which are located in each member state. And so these NCBs, let's say, these Interpol branches within the national police forces, act as points precisely of connection between the national authorities and the General Secretariat of Interpol, which is in fact let's say, the body for connection and coordination. Now, Interpol does not have arrest powers, nor does it have autonomous jurisdiction. So it's very clear, it's very important to understand this. When they tell you, oh, but Interpol is investigating, if the client tells you this, as often happens, how can I put it? They actually live in these almost movie-like fantasies, right? Fantasies that perhaps really come from Hollywood screenplays, excuse me. It doesn't have autonomous arrest power nor jurisdiction. The role of Interpol, as I was saying, is simply to facilitate international cooperation by making available databases, investigative tools, and notices for finding people. So, databases, which are now almost all electronic, investigative tools, meaning operations that can develop into activities similar to those of the National Judicial Police, and of course, the notices themselves. So the main functions of Interpol therefore include the exchange of information, fundamentally, between international police forces, operational support, when it comes to precisely setting up investigations, transnational investigation operations, management of international notices. And here we get to the topic of the famous notice, red notice, as we will see, and so on, the notices, right? Which are actually nothing more than notifications to facilitate precisely arrests and investigations. Then there is also the aspect, the task of training, technical assistance for law enforcement. So there is, how can I put it, a cooperation also regarding the creation of standard operating protocols between the police forces precisely that are party to the international treaty. And in general, this is a very important function from the standpoint of criminal policy and assessing the evolution of, well, a criminological assessment, right, of developments in the criminal world. It also has a significant monitoring function for organized crime, terrorism, and human trafficking. What's very important, in short, what a lawyer needs is to have a thorough understanding of the typology of Interpol notices. Many times you've often heard of red notice, Interpol red code, and so on. Let's actually see how they are classified and what types of notices exist. Interpol uses precisely a system of color coded notices, called notices, for cooperation between international police authorities. Each type of notice has a specific function. The first is the famous red notice, the red code. What is the red code? It's a request to locate and arrest for extradition. So if you have a red notice against you, you will be arrested. The red notice is the best known and also the most used of Interpol's notices. It is officially issued at the request of a member country, typically for the location and provisional arrest of an individual for the purpose of extradition. For example, right? Someone was wanted by, if I'm not mistaken, I don't remember which country. So a red notice is issued, it's circulated, and it basically says if you find this person, locate them, arrest them provisionally, and then we will make the extradition request. What are the characteristics of a red notice? Well, it's not a warrant. Technically, it's not an international arrest warrant, but it's a request for cooperation to detain a wanted person. So, not an arrest warrant, but a request for cooperation to detain them. It is published in the Interpol database and can be either public or restricted. It's very important to understand that a notification that is a notice can be either public or restricted. And we'll see this later because lawyers and also the parties involved have a limited ability to check if a person is subject to a red notice by making requests precisely to the headquarters in Lyon. The arrest of the person subject to a red notice depends on the local legislation of the country where the person is found. That country can decide whether or not to carry out the arrest based on bilateral or multilateral extradition treaties. So, with a red notice, I detain you. I'm putting this in very crude terms. I basically take you to the police station. I see who issued this red notice. I run the checks, and then it will be decided whether to put you in jail, whether to start an extradition process, and so on and so forth. In practice, we will also see what happens in Italy. Second type of notice. So we've seen there is the red notice, then there is the blue notice, the blue code. The Interpol blue code is that code, that type of notice that triggers the collection of information. That is, blue notices are issued to obtain information about an individual. So generally, information is requested, such as identity, location, that is where they are, what they do, where they reside or stay, and then of course information about their criminal activities is also requested through a blue notice. One can also request a collection of statements, testimonies, or even track a subject's movements. So it's an activity very similar to what we call observation and surveillance, to use language that is familiar and typical for Italian criminal lawyers. So a blue notice does not involve a request for arrest, but simply serves to track and monitor individuals involved in criminal activities. The third type of of notice is the green notice. So the green code, which is an alert about a person's potential danger. Green notices are used to warn member countries about people who pose a threat to public safety. So they are used to report dangerous criminals who move between different countries. Another important purpose of the Green Notice is to notify police forces and law enforcement agencies about innovative and emerging criminal methods. Continuing with the list of notices, we then have the yellow code, the yellow notice, which concerns missing persons. A yellow notice is issued to help find missing persons, generally for minors abducted by a parent or third parties. So anyone who also does some civil law should be familiar with the yellow notice. It's the classic type used, for example, when, let's say, In the case of international child abduction, it's typical, right? It's also a typical case now in Italy, given the incredible number of mixed couples. So, the famous cases of children taken to Russia, to Brazil, or to countries that are or are not signatories to the 1980 Hague Convention on Minors. In short, yellow notice, remember, is for missing persons. So it generally concerns minors, but it can also concern people who are unable to identify themselves. For example, individuals with mental disabilities. A yellow notice can also be issued for adults who have disappeared under mysterious circumstances. So those people whose fate is essentially unknown. There are other notices, that is, the Black Code, which concerns the identification of dead bodies and which is used to identify unknown bodies in cases of suspicious or violent deaths, or to cooperate between international police forces for identification, for forensic identification. The last two notices are the orange one, the orange code pertaining to threats to public safety. So the orange notice is used to report threats to public safety, such as explosive devices, dangerous weapons, or new criminal techniques for carrying out terrorist acts, or the presence of dangerous chemical or biological materials in a territory. This is obviously it's a code that is used mainly in the exchange of information between police forces and so between the national Interpol offices, which obviously deal with counterterrorism and intelligence essentially. The last type of notice is the purple code. So the purple notice, which is used to share information on the modus operandi of criminal groups and to help police forces with prevention. The purple notice is, let's say, most often used to communicate and share information about various methods of counterfeiting important documents and different types of currencies, or it is, let's say, used to give notice about specific methods of drug or weapons trafficking. A classic type of purple notice is one that is fundamentally promoted by the DEA in cases of large scale trafficking, for example, of cocaine between South America and Europe, where the goal is to, let's say, equip the national police of the receiving country with information on new storage methods, for example, for the drugs, I don't know, in furniture, or through chemical transformations, dilutions in let's say chemical compounds or situations like that. The purple notice is also used to give notice about cyber attacks, financial fraud. For example, a case involving a purple notice is what happened the other day in Belgium, where, for reasons that are still not well known, there was even a sort of standby of the digital control system for precisely air traffic. And so, as you know, there was a shutdown for almost an hour with a no-fly zone and closed airspace. And so purple notices were issued in this case where the various activities, the various police forces belonging to Interpol, were trying to exchange information and understand what was happening. Quite interesting, however, is the procedure for issuing a red notice, because fundamentally, in our work as lawyers, we find ourselves in the concrete situation of being called by someone who is arrested, perhaps in Italy, or rather almost always in Italy, precisely because they were wanted by a different country. So, how does a request from a member state begin? The member state, through its judicial authorities or police force, sends the request to the Interpol National Central Bureau of its own country. The request must therefore include the valid national arrest warrant, the details of the charge or the applicable penalty, and a description of the wanted individual. So it's clear that the red notice refers either, as we've said, to a pre-trial detention order, which requests the arrest of an individual to then extradite them to face trial. And so then we talk about the well-known request for procedural extradition. Otherwise, when it's a matter of a, how can I put it, a sentence that has been issued against an individual, perhaps one that is already final, well, the red notice can refer to a request in executis. So the second phase is that of the assessment. And so there is the submission to the National Central Bureau. And then as a second phase, we have the legal assessment by the Interpol General Secretariat. The General Secretariat, which is based in Lyon, verifies the request's compliance with Interpol's fundamental principles, including the absence of political, religious, or racial motivations. That's Article 3 of the Interpol statute. Right now, I don't know if lawyer Mantini is present today. I don't know if she's present. Who is a new? Yes, I'm here. Exactly. Who is a new member? And later we'll basically talk about it. And with lawyer Mantini, perhaps we can also comment on it. We had a very particular case where Russia allegedly issued, or rather did issue, an arrest warrant for a lawyer who is now a refugee in Italy, also because he had a second nationality. So this person was registered in the Interpol network for a probably abnormal trial, although it's not known if it's abnormal or not. A problem that could arise from that registration is the Secretariat's assessment of whether that registration in the database is characterized or not by political, religious, or racial motivations, and so on. Characterized or not by political, religious, racial motivations, and so on. So we have submission and registration, so to speak, an assessment by the General Secretariat, and then we have the actual publication of the red notice, which, if approved, is published in the Interpol database. Okay. So once phase 3 is completed, one can potentially proceed to a provisional arrest and the start of the extradition phases. That is, if the subject, because first they must be located. So if the subject is located, the local authorities can proceed with the provisional arrest, but only if an extradition treaty exists with the requesting country. In reality, it's not exactly like that, in the sense that in practice, I mean, I've put it in legal terms, but obviously, if a person is registered in the Interpol database, they are, in any case, temporarily placed under arrest and in Italy brought before a magistrate. And the magistrate, in the absence of an international agreement with the country that registered that person as wanted, will decides whether to release them or not. The time limit in Italy is 5 days, as we mentioned the other day with lawyer Mantini, but in reality, in institutional practice, even though the Code of Criminal Procedure provides for that deadline, generally within a couple of days, the president of the Court of Appeal decides what to do with the captured person.